the podcast. I'm Nupur, and joining me today is Odile, a lawyer with around 17 years of experience and a creator of Digital Antigone blog, where she shares her thoughts on different digital law topics. Welcome, Odile, to the podcast.
Thank you, Nupur.
Today, we will be discussing some questions around artificial intelligence law, the AI laws, especially the European Union AI law. The European Union has displayed commendable foresight in tackling the challenges posed by AI technology and its potential societal impact. The EU proactive approach to AI regulation through the AI Act set a remarkable precedent for many other regions. The EU AI law provides a comprehensive framework designed to govern the development, deployment, and the impact of AI systems. One of the key aspects of EU AI law is the establishment of a regulatory framework for categorization of AI risk based on their level of risk. The risk generally ranges from unacceptable risk to high risk to low risk systems. Odile, what are your thoughts on this risk-based approach in the EU AI law system?
Thank you for the question, Nupur. Just as a preliminary remark, I think it's just important to note that first, the EU Act is not yet adopted. And second, that I think that being a leader in this field, from a regulatory perspective, may set some precedent and golden standard and may represent a very good opportunity for the European Union and as well as the company to lead the way. Having in mind, of course, the precedent of the GDPR. And third, you said that the future EA Act has a risk-based approach, but I think it's also important to note that it has as well a horizontal approach, meaning that it targets every sector, every EI system that would be put on the market. Regarding specifically the thing of the risk-based approach, I think that first, the European Union just made a very long and hard work on that topic for years, including white papers, study, consultation with many stakeholders, and it has also made some draft proposals asking for feedbacks. So the EU needed to take a side between the risk-based approach and the right-based approach, which is more like, the GDPR. But the risk-based approach seems, for me, more in line with, the objective of the European Union, which is to find the right balance between the opportunities of the growing artificial intelligence and any drawback pitfall of the EI. So I think that it was a good way to deal with this thing. The risk-based approach is also used, for any cybersecurity requirement. As you said, requirement and obligation just follows the risk induced by this new technology, this new system. And legal obligations are very tailored to the concrete level of risk. Some author would have said that maybe they would have preferred some right-based approach, for all matters regarding, any abuse with fundamental rights, discrimination, unfair access, and so on. And just as a final remark on this question, when in November or December last year, the ChatGPT was just launched on the market. Everyone was just talking about generative AI or large language model foundation models. And this launch on the market just revealed some difficulties of this risk-based approach in the regulation. And then in June, in the last version that was adopted by the Parliament in June, Article 4, I don't know if anyone have just the occasion to read it, but with the Article 4, now it offers, the minimum obligations that apply to all EI systems. So for me, it's not a right-based approach, but, you have this way to maybe just to counterbalance what was said with the risk-based approach, and we know exactly what is in the mind of the European legislator. So it's the risk-based approach was a good thing if you want to foster EI, and we need, I think, to foster EI, not to lose the race against other major states. So it was a good way to do it. But with this Article 4, you have this kind of counterbalancing, this kind of risk-based approach, but not really a right-based approach.
Yeah, definitely. I would agree that risk-based approach taken by the EU in its AI law is an important step forward in ensuring the ethical and responsible use of the AI. And also, the categorization reduces the compliance that the organization are required to take based on the level of adoption of the AI risk. That is also good way to put less burden on systems that are not too risky. Coming to the next question, the rapid rise of artificial intelligence has created a new set of challenges for the policymakers, which we already discussed. One of the fundamental aspects of the AI law is ensuring ethical use and decision making. How can policymakers strike a balance between fostering AI innovation and safeguarding against the potential misuse? I think you covered some of the points in the earlier reply, but do you think, or do you have to add something more here?
Yeah, I think that regarding fostering AI innovation, I think that European Union has a budget for that. I mean, there are plenty of tools to foster innovation, and I would just mention, just call for tenders, sandbox regulation, educations, and I think there's a lot to do, and the European Union is plenty aware that regulation would not be sufficient to foster AI innovation. So again, there's plenty of tools, just like for other fields as well, to foster the other technology, just like blockchain and so on. So the EU will probably is setting all this kind of tools to foster AI innovation. The second point regarding potential misuse, I think that not everything is in the end of policymaker. I think that everyone, I mean, you, your friends, your family, your colleague, and everyone has a role to play. I will not reduce the question to policymaker, because regarding, safeguarding against potential misuse, because people should take their own responsibility and get educated to this new technology, whatever their age, their position, their role. And I think it's very important that everyone just be, aware that there's a new tool on the market, which is called artificial intelligence. It has big opportunities, it has big pitfalls as well, but you don't have to be afraid or maybe just wait for a state having some regulation, some law impeding, some use of this AI. Of course, there would be some regulation, and it's very important, but you as a citizen, you need to know what is AI and have this kind of AI literacy. I think it's very important.
Definitely. And the point you mentioned regarding fostering innovation, how to balance between innovation and the potential misuse. Definitely, there are a lot of arguments that excessive regulation could stifle innovation and hinder the development of AI solution. But like you mentioned, the availability of different sort of mechanism to promote the use of the technology, like providing sandbox or other areas. Of course, policymakers may consider bringing in some other forms of incentives for businesses to responsibly innovate. With AI, this could include grants or other forms of government support for business that develop ethical AI system and application. Also, I think for businesses that are already adhering to AI ethical principles, they can also be rewarded in best way. And the point you mentioned that everyone is responsible, is not that one stakeholder is responsible or few stakeholders are responsible for ethical use or responsible use of the AI. In the end, it is everybody's or everyone's best interest that this balance between AI, innovation, and safeguarding against the potential misuse is achieved.
Yeah, definitely.
Coming to the next question, does the current approach of EU AI Act effectively addresses the technical realities of AI uses while balancing innovation, fundamental right, and ethical consideration? And how does it impact the vast majority of AI use cases that are not considered very high risk?
I think it's too early to respond to the question, how well does the current European regulatory framework address the practical implication? Because regulation is not just about regulation and law. It's need to wait for the whole legal system to be put in place to know exactly what is the regulation with artificial intelligence. I think that if we just take a look at what is now in the AI regulation and what is to be voted by the Parliament and consider, and I think that it is not sufficient, because the complexity of the AI value chain will embrace many other topics. There will be many litigation, and among the EI regulation, of course, there would be the specific EI regulation system, but there would be also, the classical contract law, copyright law, and data protection. I mean, all these fields that all lawyer knows very well. It would be mixed. Yeah, I think in most of the litigations that would sooner or later just came in front of the court. So we need to wait for the whole legal system to be put in place. And I think that when we have more or less this kind of the whole legal ecosystem, we will have a clearer view of what is done for for each EI system, and maybe specifically for the more general EI systems that everyone is supposed to use. But one of the other questions as well, and as you said it, just about the generality and the fact that people can easily use EI with the foundation model, just like ChatGPT and other. I think that it was one of the points with the EI regulation. Sometimes I think that people just get confused about, is that really artificial intelligence or a very good and developed software? I mean that sometimes some things, some product would be called smart, but it does not imply automatically artificial intelligence. Saying that maybe one of the points for me to be sure what is the exact scope of the EI regulation, because I think that some people just get confused with that. Is that the very developed software, which does not imply artificial intelligence and machine learning, deep learning, and is it just a smart product? And the regulation for the smart product wouldn't be exactly the same as the EI regulation. So again, a lot of things is to be done, to be clarified. I mean, with years, with litigation, case law, and maybe doctrine as well. But for sure, I think that, as you said it, I think that is it very technical for some points of regulation, and lawyers will have to work hand in hand with engineers to know exactly where the scope of the new EI regulation apply or not, specifically for the day-to-day smart product use.
Exactly. That's what I would say, that the law is still at very nascent stage, and the use cases of generative AI or other forms of AIs are also increasing day by day. So it will just evolve over time, and the interplay with different laws that you mentioned is another prominent point that will need to be addressed as we see more and more use cases of the AI, or even with more level of adoption of the AI law, those questions will revolve around. But at least it's a good start. At least establishes a good level playing field by providing a harmonized regulatory framework across the EU. Mm-hmm. And we will wait and see where it goes in coming times.
Yeah.
Coming to the next question, international cooperation on AI regulation is vital due to its global impact. How can countries work together to create harmonized AI laws while respecting cultural and legal differences?
Good question. I think that things are moving forward, and there are different work in progress on that question. I think that at the level of the Council of Europe, United Nations, and UNESCO levels, there's work in progress and some binding agreements that need to be drafted and are currently under drafting. But I think that your question is not specifically turned to artificial intelligence, and it just applies to all global matters. I mean, just like fundamental rights. So, and it takes really time to reach a global and international binding agreement. I mean, that's the time for politics agreement. But regarding technology, and specifically, I mean, digital technology, which are based, for example, on protocol, I think that international standards may definitely help regulate AI. I think that before regarding any global political international binding agreement, I think that maybe it would be easier for some state, for some company to just agree of some international standard. And I think that around the field of digital communication, it just proves that international standards just can work, and they are worth it, because you will exchange information and be sure of the quality of the information that you get thanks to these international standards. So I think before regarding the United Nations level or Council of Europe, because it would take time to get everything around the table and sign the agreement. I think that international standards are really worth it. And just as an aside, you mentioned the harmonization in the world, but I think as well that inside the European Union, we need to have this harmonization. I mean, of course, it's a regulation, so it should be very easy to have this harmonization, but it's just like, with GDPR, and member states really need to cooperate and harmonize their view when they need to implement, some point of the regulation. And I think we should not have any competition among member states, because I don't know if you remember, because I think it was in May or April, in the Italian Authority for Data Protection just decided to temporarily ban ChatGPT on the market, saying that it may infringe certain rights to GDPR and so on. And for me, it was just like, hey, I'm the Italian authority, I'm the leader on this field, and look at me, and I know what is right, inside the US. So, and I think we see this kind of competition among member states, saying that, okay, Italy say maybe there's something wrong, then Spain came saying that maybe there's something wrong, and then finally the European institutions say, okay, we need to set, some inquiry to know exactly if there's something wrong or not with ChatGPT and GDPR. So I think that it's really important that member states inside the European Union has this harmonized implementation of the regulation.
Yeah, that's so true. That's very true that sometimes different country adopt different mechanism, even though the directive may be uniform, but they do have some level of sovereignty. They do individual step which might not align entirely. So it would be good to see some harmonization from that side, like that point you mentioned regarding Italian temporary ban on the ChatGPT. And also, I think cooperation is crucial in creating harmonized AI laws across the globe. Without it, there will always be risk of confusion and fragmentation as countries attempt to create laws independently without considering the effect of their laws that may have on other countries or other international entities. Furthermore, the other point is that different countries may have different level of AI maturity, meaning that some may have fewer regulations than other, and not all countries at this stage are at same level of AI maturity. Some are too progressive, some are still in the phase of just initial adaptation. So also those factors needs to be considered. And international cooperation not only ensure better regulation, but more importantly, it can help in bringing more trust between nations and promote global harmony in a way. International cooperation, like you mentioned, is like more around setting up of international standards or setting up some form of global forum, does require adoption of multi-level and multi-stakeholder approach where we see countries collaborating. Coming to the last question, privacy concern arise with the extensive data collection required by AI system to learn and improve. How can we strike a balance between utilizing personal data for AI advance and protecting individual privacy? Do you have any additional point to add here?
No, I think that just, the two sides of the question. I mean, we need to wait for the right implementation, of GDPR, and what are, the position of the national regulatory authority on this aspect, or any European case laws that will sooner or later arrive. So they will have all the answer for that. But again, I'm going back to, I think, was the first question or second question. I think that, again, it's in the end of each user. I mean, it's just like when you just open your internet browser, when you just go on any website, I don't know if many people just have time to set their cookies and just have a look to the terms and conditions. And it's just to everyone to be aware of what they are doing with the internet, what kind of trace they could, let or not, on the internet when they're going from one website to another. And really, it's not everything is in the end of policymaker. We need, as a citizen, as a user, to be educated, to give, the right instruction to our children, to to talk with colleagues and friends about our own experience, and the internet. And I think it's very important that everyone just be aware of what they are doing, with the internet. I know that sometimes you can't reject all cookies because your website won't have, all the potentiality it should have, and sometimes you are obliged to accept it. But when you have time to set up your cookies and know exactly what you're doing, and for example, when you use Deeper, you don't have to put any personal information, and so it's very important just to be aware of what you're doing, through the internet, just to manage or at least a bit control your own data.
Yeah.
You won't be for every situation in the position to control your own data. We know that for sure. But when you have time, when you have the occasion, you should be aware of what you are doing and maybe exercise your right. Exercise your right about the right to be erased. And saying that okay, why do you have this kind of question about my personal data? I think that it's not proportionate, and so I think that yes, the citizen user need to know their rights and just maybe say stop to some usage that are applied by the use of any website.
Yeah, definitely. And also, that is a great point that people or the users should be mindful of their own data. And there are, like, the GDPR requires providing opt-in, opt-out provisions. So people should be able to see what they consent to more broadly. But also, the other point is that not every country still in the world have data privacy law. So there is another thing to consider from the regulatory side. Maybe in those countries, regulators may try to bring some laws or regulation where companies are required to have consent mechanism in place for use of data processing technique that minimizes privacy risk and make it easier for the users to understand how their data are used. To an extent, GDPR has done a good job in this area. Any more thoughts to add, Odile?
No, for me, so
okay.
It's fine.
Thanks a lot. That wraps up our discussion today. Thanks all for tuning in for the session.
Thank you, Nupur.
Thanks a lot, Odile.